Thank you for coming, everybody, in person and online. I'm very happy to introduce our speaker for today, Dr. Stuart Baran. Stuart is a barrister and specializes in intellectual property at 3 New Square. He had a degree in chemistry, and a doctorate in chemical physics at Oxford, and he was called to the bar in 2011 and has practiced from 3 New Square ever since in all areas of IP, but with particular emphasis on trademarks and patents. He has appeared and led in every IP forum, from the UK IPO and the European Patents Office to the EU General Court and the Court of Justice, as well as the UK High Court and the Court of Appeal and the Supreme Court, as we'll find out today. And he's been involved in a number of seminal cases across the IP spectrum, including Activists and Lilly, Sky and Skyskick and Thaler and Comptroller-General. Now, alongside his private practice, Stuart is standing counsel to the Comptroller-General, which means he represents and advises the UK IPO and government departments on intellectual property issues. He was awarded Legal 500 Junior of the Year for IP in 2018, Managing IP Junior of the Year in 2021, and was profiled in a Juve patent One to Watch in 2023. Outside of work, he is a keen orchestral violinist and a cook and Italophobe. And today we're very happy that Stuart will be talking to us on inventorship in light of Thaler versus the Comptroller-General. Thank you.
Thank you, Jennifer, and thank you all. Thank you for asking me along to discuss this extraordinary case. It's a great pleasure to be here. The plan, roughly speaking, is that I'll take a moment to introduce the case, what it was about, and then take you through how the Supreme Court has resolved the questions on the appeal. And then, having done that, the second half of the talk, I thought there are broadly 3 questions I'd like to look at about quite where this judgment leaves us, what it has and what it hasn't resolved. And those 3 are, first, why the case took the shape that it did, and in particular, how questions of procedure might slightly, in this case, have overtaken some of the substance. Secondly, what does all of this mean, of course, for patents arising from AI inventions in future? And then thirdly, whether justice is right to duck this one and to leave any development of the law in this respect to Parliament. Now, those aren't really completely separate or separable questions, so we'll consider them in the context of a few particular unresolved issues arising out of this case in particular. Before I get to those, though, there is a boring but slightly compulsory thing I do have to say. I, as Jennifer kindly explained to you, appeared in this appeal in the Supreme Court in my capacity as standing counsel to the Comptroller-General of Patents, Designs and Trademarks, which sounds very grand, but really just means I'm on an approved list of 2 advocates to the Intellectual Property Office, the UK IPO. That's a sort of a side job that I'm very lucky to have and which I really do love doing, but it's only proper and fair for me to say that today I'm not here on their behalf, and any views I express shouldn't and can't be attributed to the UK IPO. The government is, as a rule, generally very keen not to be associated with my views, and so I think it's only fair to them that I make that clear to you as well. So, with that slightly boring bit out the way, to the substance. I can take the facts of this case very quickly indeed, because there are very few of them that actually matter very much. The appeal is about 2 patent applications made by Dr. Thaler, who was the appellant before the Supreme Court. Now, I've listed here what the titles of those 2 patent applications were, but perhaps unusually for a patents appeal, the contents of the patents are pretty close to immaterial. I think it might be right actually to say that neither party made reference to them at all during any of the 3 appeals. But as it is, those are the 2 inventions. One was to a new food container based on a fractal geometric shape, and the other was a flashing light as a sort of a security device, a flare to show where you were if you got lost. But as I say, that doesn't really matter very much. For present purposes, what is important is that no objection had at this point been raised in relation to the patentability of the inventions. So the inventions themselves hadn't been objected to. The UK IPO had taken no point that they lacked novelty or that they lacked inventive step or anything like that, for example. So for present purposes, we can proceed on the basis that the inventions are patentable inventions. So having told you this is a patents case where the patents don't matter very much, or at least their specifications don't matter very much, I'd better show you what does. The appeal was really centered on the forms filed alongside the patent application. UK IPO Form 7, as it happens, and that form centers on who, or indeed what, for this case, was said to be the inventor, and who was said to be entitled to apply for the patent. The inventor, as you can see there, was said to be DABUS. That's an acronym. It stands for Device for the Autonomous Bootstrapping of Unified Sentience. Your guess is as good as mine, but as you will have gathered, it's said, broadly speaking, to be an autonomous AI. For present purposes, it's just a machine that was asserted to have invented the two inventions that we've seen without any human involvement. Now, I should pause for a moment on a point that in essence is just one of procedure, but actually becomes very important to analysing the scope of this appeal and the scope of what's been decided. The point is this: the facts, the ones here, namely that DABUS actually devised the two inventions on its own, are assumed for this appeal to be true. I say assumed because they haven't been tested, they haven't been found by anyone. They are, to say the least, controversial in the world of AI. There certainly are some expert organizations and individuals who do consider that AI, including DABUS, has now developed to a level where it's capable of being and is autonomously inventive. Equally, there are also many of the biggest and most serious organizations and experts who strongly disagree. We'll get there, they say, maybe even quite soon, but no AI has got there yet. Now, certainly, the controller is in no position to be adjudicating that debate. But anyway, even in a case that isn't complicated by considerations about how autonomous an AI really is, even in a case where it's just an ordinary run-of-the-mill human or scientist who is said to be the actual deviser, the controller doesn't have the capacity or access to the information, really, to be investigating and adjudicating an assertion of inventorship and whether it's factually true on what is, after all, an ex parte application for the patent. That's to say, where there's nobody to put forward a contrary position. So the asserted facts there are taken as read as they were for this appeal. I've laboured that a bit, but it's going to be very, very important. More than that factual assertion, though, about actually devising the inventions, DABUS is asserted here to be their inventor. And that, of course, is really an answer to a question of law under the Patents Act 1977. And that legal question, of course, is the one that's the central part of this appeal, as we shall see. The second important assertion is the next one there on the slide. If you, the applicant, are not yourself the inventor, you must indicate to the office how it is that you come to be the one applying for the patent, why you are entitled to do it. For this, Dr. Thaler, the applicant, just wrote those words there, by ownership of the creativity machine DABUS. So again, the assertion here is in two parts. There's a factual part, Dr. Thaler owns DABUS. That bit, again, for the same reasons, is taken as read. The controller hasn't got the time, the resources, the information, as we said before, to go behind a factual assertion like that. It also comprises a legal component again. Because Dr. Thaler owns DABUS, he is therefore, it is asserted, entitled to apply for and be granted the patent on what he says is DABUS's invention. And that's the bit, again, that's to be tested on appeal. So before we look at the three questions that the court addressed, we do need to look at the two statutory provisions that were central to what is in essence a very narrow dispute of statutory interpretation. First, section 7 there, I hope that's legible at that size. It gives what's been called a complete code, that was Lord Hoffman in the Yeda case, for persons entitled to apply for a patent. So a few points to stress here about each of the subsections. The first one makes it clear, I would say, that only a person may apply. We'll skip over the second and come to it last because it's going to be the most important. The third shows, what we mean by the inventor. It is on the facts the actual deviser of the invention. There's a little bit about that in YEDA, what that means, but really it just says, well, it means what it says, and it's not a deemed deviser or pretended deviser is the language of the House of Lords in that case. But really, actual deviser just means the one that actually devised it on the face of those words. And then subsection 4 sets up a presumption that the applicant is the person entitled under subsection 2, except insofar as the contrary is established. Clear enough. As to number 2 then, subsection 2, there are 3 categories of person laid out, a complete code, as I said before, who can be granted the patent. First, and unsurprisingly, the inventor. Second, to bowdlerize it a bit, someone else who is entitled by operation of law to the whole of the property in the invention when it was made. Or C, the successor entitled to the person or persons, we'll come back to that many times, in A or B. So the setup of this section already contemplates that the categories of potential applicant in B and A are persons, A being the inventor. So that's section 7. Now to section 13, a bit more of a procedural rule, but absolutely linked to the one we've just seen and having a pretty serious substantive consequence. We'll focus on section 13.2, which sets out some things an applicant for a patent must do in relation to the inventorship. I should say that the emphases in both these provisions are mine, they're not in the original. So subsection 2 there, unless he's already given the Patent Office the information, an applicant for a patent will, within a prescribed period, file with the office a statement, A, identifying, again, the person or persons whom he believes to be the inventor or inventors, and B, so both have got to be provided, where the applicant is not the sole inventor or the applicants are the joint inventor, indicate the derivation of his or their right to be granted the patent. So that's those 2 things that we saw the factual assertions about on Form 7, and it's not a coincidence that Form 7 looks like that. It just tracks what section 13.2 requires them to do. So what happened then? The hearing officer at the UK IPO refused both the patents. That was on 2 bases, corresponding to the 2 bits of 13.2. First, Dr. Thaler hadn't complied with 13.2a because in relation to the inventor, that provision required him to identify the person or persons whom he believed to be the inventor. He hadn't done that because he'd identified only DABUS, and it was common ground that DABUS was not a person. Alternatively, we noticed that under section 13.2, both of these things have got to be supplied. Alternatively, in any event, Dr. Thaler hadn't complied with 13.2b because the assertion of ownership of DABUS didn't make out any actual basis for entitlement to apply for a patent for an invention that DABUS had invented. Dr. Thaler appealed from that refusal, and for present purposes, we can suffice to say that the appeal was dismissed by Mr. Justice Marcus Smith in the Patents Court, who found that the hearing officer was correct in respect of both limbs of the refusal. The Court of Appeal dismissed the second appeal as well, but only by a majority. Lord Justice Arnold and Lord Justice Burst disagreed with one another, and so Lady Justice Elizabeth Lang was put in the perhaps unenviable position of exercising a casting vote between the court's 2 intellectual property specialists. As it was, she cast it with Lord Justice Arnold to dismiss the appeal. Lord Justice Burst thought that rather than looking at what the statute said, the answer to how to get through all of this lay in the legislative history. There had previously been a more stringent set of requirements in relation to satisfying the controller that the inventor really was who the applicant said it was. That, Lord Justice Burse reasoned, had been displaced when it came to produce the Patents Act 1977 in favour of a system where the controller didn't get involved unless and until a third party turned up within a prescribed period and claimed that the proper inventor was them. And at that point, a determination would be reached on an inter partes basis, the two contending inventors fighting it out. Lord Justice Burse thought that meant that the controller's role had been removed altogether at the application stage. He couldn't reach any judgment under Section 13 about what had been said about the inventor. He simply had to take the information, publish it unthinkingly, and wait to see if an allegedly wronged third party turned up to object. Lord Justice Arnold and Lady Justice Elizabeth Lang thought that read the statute down too much. A mandatory provision which said the applicant must name the person who was not fulfilled in circumstances where it was common ground, where he had not named a person who anything. The majority and minority similarly disagreed about 13(2)(b, showing the entitlement to apply. Here, Lord Justice Burse took a similar sort of position to under the previous subsection. Essentially, it was no longer the controller's business to be examining the correctness in law of the assertion that had been made. He simply had to record there was some ink on the page in answer to the 13(2)(b) question, and that was that. The majority instead found that there was no applicable rule of law that could be identified by which an AI's proprietor could be assumed automatically to be the proprietor of its inventions. The doctrine of accession was the one that Dr. Thaler had rather tentatively at that stage put forward, articulated for the first time on second appeal, which is never a great start in a one-issue piece of litigation. Now, I'll tackle this a bit more when we talk about the Supreme Court's judgment, but suffice to say that Lord Justice Arnold and Lady Justice Elizabeth Lang weren't convinced about the applicability of the doctrine of succession. So to the Supreme Court, and Lord Kitchin, the first and so far only intellectual property specialist justice on the highest court, the Supreme Court, wrote a judgment on behalf of a court that was unanimous. They approached the case on the basis of three issues. First, the scope and meaning of inventor in the context of the Act. This involved grappling, of course, with many of the points underpinning the refusal under 13(2)(a). And second, was Dr. Thaler nevertheless the owner of DABUS's inventions so as to be entitled to apply for the patents? And this engages lots of the points underlying the refusal under 13(2)(b). Finally, and flowing from those two, was the hearing officer entitled to hold that the applications would be taken to be withdrawn? Having done the groundwork in the previous two questions, this sort of takes the 13(2)(a) and (b) questions head on. So we'll take these three in order. The Supreme Court essentially accepted the controller's position on what does inventor mean. First, the inventor must be a person, and a principal basis for this was simply looking, as we have done, at what sections 7 and 13 said. The structure of those, the way they're worded, only really allowed for one sensible interpretation, that the inventor is a person, and indeed a natural person, they went on. That was also consistent with an earlier unanimous decision of a committee of the House of Lords in Yedder, where Lord Hoffman had said the inventor was the natural person who came up with the inventive concept. They then confirmed this analysis by looking at other sections of the Act to set the overall scheme in context. First of all, section 2(4), which is about disregarding prior disclosures in the context of novelty. Sections 8 and 37, which are determinations of entitlement, where you've got a fight over who is entitled to the patent, respectively before and after grant. And in each of those cases, we won't go through all the wording one after the other, they do so in the judgment. In each of those cases, it's pretty clear from the wording, the same as it was in section 7 and 13, that it's understood by the draftsman that the inventor was a person. All of that being so, they took a clear position that DABUS wasn't properly the inventor for the purposes of the two patent applications. So that did with issue 1. Issue 2, was Dr. Thaler the owner of DABUS's inventions and therefore entitled to apply and be granted a patent? In short, this one got a sound no. Dr. Thaler had put forward as his principal basis for this the doctrine of accession, as in the court below. A fused doctrine of Roman law that says, putting it informally, that the owner of the thing owns the fruits of that thing. Now, the classic examples of accession are fruit from a tree, a calf from a cow, and sometimes sort of alluvial extension of an island mass where the earth washes up in the water and the island sort of grows, if I can put it that way. Crucially, though, the point here is that the original thing in each of those cases is generating more of that thing and not generating a new thing of an entirely different category. Another way to think of it, perhaps, and how I put it at the hearing, is that in cases of true accession, the progeny are defined by their relationship to their parent. The offspring of a cow is, by that definition, a calf, because it came from a cow. The fruit of an apple tree is, by that definition, an apple, because it came from an apple tree. In each case, you can categorize the offspring just by looking at who the parent is. Happily, not something you can do with human beings. Something doesn't become a patentable invention, though, just because it came from a person that we deem to be an inventor. Inventors can have plenty of other completely non-inventive ideas. And indeed, the whole ethos of the Patents Act is that invention is a special, and indeed I would say desirable, is underpinning the same thing, process. A process that has certain characteristics, we might call them relative characteristics, in the sense that inventiveness is measured with respect to others' work and looking at what ideas are already out there. To work out whether something is an invention, it certainly doesn't suffice just to look at who came up with it and ask if that person is an inventor. Here, though, the Supreme Court cut through things pretty clearly and dealt with it relatively tersely. In essence, they adopted Lord Justice Arnold's reasoning, which he expressed characteristically more fulsomely. All the examples of accession given in the authorities, they said, are about tangible property derived from tangible property. Apples from trees, calves from cows, and so on. And there's good reason not to extend, in principle, that to a case like this, which is very different. Different because with intangible property like an IP right, it by its nature is generally non-rivalrous, by which we mean two people, of course, can possess or consume an idea at the same time. The doctrine of accession could therefore not be read across from apples and apple trees to an AI and its alleged inventions. And of course, all this argument about compliance with section 13(2)(b) proceeded on the basis that DABUS in fact was the inventor. And so there was, on that hypothesis, no failure under 13(2)(a), because otherwise there was no point analyzing B. Either failure would have been fatal to the applications. So if Dr. Thaler had fallen at the 13(2)(a) hurdle, strictly the 13(2)(b) question didn't arise. So that then got us to the third issue, which is really sort of what's the consequence of all this? Was the hearing officer right to deem the applications withdrawn? This was just found to be an inevitable consequence under section 13(2) of the earlier findings. And centrally here, the Supreme Court relied upon a distinction that I drew. I started to worry I was saying it too often in the hearing. The really central point was that there is a true distinction between, on the one hand, looking at the factual veracity of an assertion made by the applicant. Is this person the person that invented the thing you say they invented? Something the controller is not empowered to check, the facts. And on the other, examining whether an answer has been given which in law could be the right answer to the question, respectively of inventorship and entitlement to apply, if the given facts are assumed to be true. The controller had assumed the facts, as we've said. DABUS devised the invention and Dr. Thaler owns DABUS, assumed they were true, but was right, nevertheless, to object on the basis that even if true, these weren't proper answers to the questions posed in the statute. Dr. Thaler had not complied either with limb A or B, and deemed withdrawal is expressly set out in the statute as the inevitable consequence of that. So that's a quick tour through what happened, what was decided, what the reasons for it were. The Supreme Court's decision is pretty emphatic and is admirably clear, if I may say so. And that's something that the UK IPO, I can tell you as their standing counsel, is always most relieved about, actually. Working for them is genuinely different from working with private clients in lots of ways, but particularly because a lot of the time, they genuinely would rather lose but get a clear reasoned rule that they can apply than get through a case by the skin of their teeth and emerge with a judgment that's difficult for them to apply to future cases. So the court's decision is really clear, but that doesn't mean that all of its consequences are clear. I mentioned earlier and laboured the point a little bit deliberately that this case proceeded on the basis of assumed untested facts. To start with, that, I think, makes this case a pretty unhappy basis for policy making of the sort that the appellants were urging. The appellants sort of ran a slightly half-hearted case that, well, no, what the section really means is you just have to believe this was the inventor and just don't worry about the person bit they weren't thinking hard enough. But really what their case was this is what the law should be. It's undesirable if this isn't accommodated because this is a very serious and important set of technological developments. And the nature of our patents law is it should be able to cope with technological developments. If we've shoehorned a whole bunch of digital and internet-related law into a Copyright Act that was put together for the advent of the CD, then there's no reason why the Patents Act 1977 shouldn't be able to move and accommodate important and genuinely life-changing developments in technology now, they said. But I think changing the law on the basis of a very new set of facts, simply taking it on trust that those facts are actually true, and without interrogating it in any detail at all, because they couldn't, because perfectly properly, in this case, they wouldn't have the information to do so, seems, I'm bound to say, like a pretty unfortunate way to be making potentially very consequential changes to the structure of our law. Now, when I said something a bit like that in the Court of Appeal, Lady Justice Elizabeth Lang said to me, oh, but come on, we do this all the time. We just say we're proceeding on assumed facts. As long as we're clear about that and we say what they are, then a future tribunal can just measure the situation before it against what we were assuming. But of course, that's just not right here, because the fundamental problem in this case is that all the subsequent cases will also proceed on assumed, untested facts, because this procedural rule before the IPO, the only way it really could work, will continue to pertain. So we end up setting off a whole chain of decisions, potentially, based on a series of facts that half the experts in the field will tell you just aren't true, and which we've never even held up to any sort of scrutiny. I don't think that's a very clever way to be making potentially very consequential policy. I've used that phrase twice now. Why do I keep saying it's potentially so consequential? Well, because the advent of AI at speed, even though we've known it was on the horizon for some time, actually interacts with some of the most fundamental questions in our law. It's not at all cynical or facetious to note that in an age of potentially autonomous machines, vehicles, deep fakes, replacing generations of employees and so on, whether or not these poor machines should be able to enjoy patent rights isn't really question one on the to-do list. And we crash into some pretty fundamental issues pretty quickly if we're not careful. If an AI can invent, why can't it infringe? And if it can infringe, why can't it commit and be liable for other torts? And all of a sudden, we're into the realms of some very, very fundamental questions that, to put it lightly, probably aren't best tackled through the prism of an appeal from a single hearing officer of the UK Intellectual Property Office. But it's not just about crashing into fundamental questions about AI either. This appeal goes to the centre of what it means to invent, which surely must be central to the whole patents scheme. Just to give you one example, Section 3 of the Patents Act, which in essence says you can't have a patent for an invention that's obvious, mandates that that obviousness is considered through the eyes of a skilled addressee of the patent, a person skilled in the art. Now, if all the inventions in a given field end up being produced, invented, and patents filed naming the inventors as AIs, then presumably the skilled person must either be, or at the very least be armed with, an AI as well. Then quite what it means for something to be obvious to a machine that just has a vast bank of data and doesn't necessarily discriminate between things it does and doesn't like the sound of in quite the same way, doesn't have the same prejudices as a human skilled person, that could upend an awful lot of our patents law. Now, none of that's to say this is all bad. I'm not here to tell you this is a disaster and the whole thing's falling down. What I'm saying is we're playing with some blocks very near the bottom of this edifice that is our patent system when we consider this case. It's a very narrow case about a very circumscribed issue in a case the facts of which don't matter very much. These patents probably aren't going to be exploited. They were really being applied for to set off this debate. But it's very, very quickly that you suddenly find yourself crashing into the absolute fundament of what is this whole scheme, this act here to do, to incentivize, to reward, to encourage. Now, on one level, the debate going on here between, for example, Lord Justice Birse on the one hand, and the majority in the Court of Appeal, and now the Supreme Court on the other, could be said to be one, in part, about what the role of an appellate judge is. Lord Justice Birse approached this on the basis he sees a problem and he thinks he should fix it, because he's suitably well informed and suitably empowered to do so. On its face, that's reasonable enough. He knows a vast amount about these issues, as does the rest of the tribunal. And no doubt there is a bit of a lacuna here. There's a problem that needs to be tackled. But the other side of that debate says, well, this is a policy debate that's well above our pay grade, and we're very unlikely to have anything like all the relevant information in the context of this narrow appeal. So we should restrict ourselves to answering the instant question about the meaning of this statutory provision, which is pretty clear. So what is the better way to take this forward? This case can't be, by a long stretch, the last word about the interaction between AI and our patents law. Now, as you will certainly have guessed, I suspect, I really think this is one for Parliament. My tastes are relatively conservative with a very small c when it comes to questions like this in IP. But that's not a very interesting thing to say. More than that, the proper exercise that seeks to grapple with these questions of AI inventorship has to be holistic. That can be a bit of an empty word. It's easy to bandy around. But here, I really mean there's some necessary zooming out to be done before the issues can properly be tackled, precisely because the best answer to some of these very specific and narrow questions, like the one in this case, will often emerge, I think, from the answers to the very fundamental questions at the bottom of the pyramid, what role we're content for AI to play in our lives and so in our laws. The same policy exercise needs as well, crucially in my view, and not just mine, a great majority of the respondents to the government's consultation on this agreed, needs to be international. Now, patents are territorial, of course, and different territories have some different rules. But by and large, the patent systems and courts operate in a pretty cooperative way globally, and they do so out of necessity because the most valuable patents rights will almost always, or at least often, be for inventions relevant in a genuinely global market. If Dr. Thaler had won this appeal, we would, at least for a while, have been in a system where a patentee would be saying to the UK that the inventor of invention X was her AI, but at the same time signing a declaration in the US, expressly on pain of imprisonment if that declaration be false, as it happens, that the inventor was not her AI, it was her, the human owner, because otherwise in the US she wouldn't get a patent at all. Now, one can square that circle by saying, well, look, these are partly legal questions and they're not questions of pure fact. So different answers in different jurisdictions are defensible. But look, that sort of messiness just isn't going to appeal to global corporations, filing hundreds of these a day in some cases, not one bit. At least some of them would just have decided, I reckon, to vote with their feet as far as the UK goes in their patent portfolio, if that's where we'd ended up. It wouldn't pay for us, or indeed for any particular system, to be an outlier. So next to another consequence of the procedural shape of this case, several points in the hearing, the justices and Lord Kitchen in particular were anxious to ask me, would the controller accept that the application was regular if the same application had been made, but listing Dr. Thaler as the inventor and not DABUS? Now, I was very careful about how I answered that, because actually, if you think about it, it conceals a compound question behind what sounds like a single one. I say that because the two sub-questions are, first, would the controller have refused the application in such a case? But second, would Dr. Thaler have actually been entitled in law to apply for the patent in that case? I'll tell you what I said to the court, and then we can look behind it a little bit. When I was asked, I just said, well, look, if we'd been presented with these applications naming Dr. Thaler, what would have happened is nothing. Nothing in the sense we just wouldn't be here. No objection would have been raised. I even went on to say that if, in such a case, Dr. Thaler had included a line in the specification of the patent saying that the invention described hereunder has been devised with the use of the artificial intelligence DABUS described in publication XYZ, the controller would have had no problem with that at all. And the second part of that answer was necessary because a central argument from the appellants, repeated often, was that if the AI didn't receive the credit it deserved by being nominated as inventor, people who might otherwise be minded to invest in AI technology would have no idea how capable it was, no idea what it had done, and investment opportunity in AI would be missed. Now, of course, that argument's nonsense. It's not the only way to tell the public that an AI is at the center of generating an invention, to nominate it as the inventor and put its name in the inventor box. So anyway, that was my answer. The office wouldn't have objected. And the justices seemed satisfied, to my relief. You could see on their faces that it was sort of striking them that clearly it wasn't the controller who was being obtuse here. And at points they seemed to think perhaps Dr. Thaler was. But in truth, if you think about it, I'd only fully answered the first of what I said was a pair of questions. Would the controller have refused it? Of course the answer is no, but we know why it's no. It's no because provided a legally possible answer is provided to the question under 13.2a, the controller has no power to go behind its factual veracity. The answer is no because our procedural rule, mandated by the statute, is not to go behind the facts we're told. That second question then, would Dr. Thaler actually have been entitled to apply in law on these facts, is much, much harder. If the AI really did actually devise the invention, then Dr. Thaler didn't. And so Dr. Thaler isn't the inventor under Section 7, but the AI is not a person, and we know the inventor has to be a person, so the AI isn't an inventor either. So we're left with an inventorless invention. And in that case, it might be said to be impossible to answer Section 13.2a in a way that didn't just satisfy the controller procedurally, but was actually legally correct. Now, I'm a bit limited in what I can say here beyond identifying the issue, because Dr. Thaler has made, and his representatives have said in public they have made, a further divisional application for these two patents for the same inventions, but listing Dr. Thaler as the inventor. So that one may yet come across my lectern, and I better say not too much more about resolving it. But you see how the issue arises because of the procedure. This is what I meant at the start when I said have procedural considerations subsumed some of the significance of the substance of what's been decided. The only question the Supreme Court needed to answer in the case before it was whether an applicant who failed on the form to name a human inventor could properly be granted a patent. Whether it's gone further and also disposed of the question of whether an invention without a human actual deviser is patentable, remains to be argued. I will say I think there's a clear answer to that question, and I'll be interested if you think the same. Sadly, I'm not able to tell you what I think the clear answer to that question is, but watch this space, I suspect. One last point, and then I'll throw the discussion open to you all, if I may. Another open question that some people have often raised is about what we should want to do if a wrong inventor, that's to say a person, when it was really their AI, is listed as the inventor of a particular invention. I've alluded to the fact that the scheme of the Patents Act 77, sections 8 and 37 in particular, about determining entitlement in proceedings after grant, makes this an inter-parties problem, a fight between two sets of people, at least two. If the incorrect inventor is listed, it says Mr. Jones when it was really Miss Bloggs, then there's a wronged party. And she can, within a prescribed time limit, start a process to have the rightful position restored. And only a wronged party, the rightful inventor, can apply for that. But for now, at least, when the AI's owner has wrongly been credited with the AI's work, is there really a wronged party at all? And without being at all flippant, should we really care? Difficult question, actually. I'm not sure that we should. I can see that some mention of the AI is desirable, not least so that we understand fully what the process is that led to the invention. There might be some interaction with the law on sufficiency of disclosure there, but whether that provides a complete answer, I'm not certain. Certainly, deeming it the inventor is not the only way to do that, as I said to you earlier. Now, not even Lord Justice Birse, reading an approximation of the legislative history from about 33,000 feet, could find anything to help with this sort of question. I would suggest we shouldn't be even faintly surprised that the Patents Act 1977, not in any of these respects materially amended since, didn't provide for this sort of eventuality, but we clearly need to think about it. So where we end up is, look, this decision might be emphatic, it is. Admirably clear, it certainly is, as far as the issue is concerned that they were to decide. But with admirable humility, and I do mean that seriously, not ranging into things that they didn't have the information to do, and that Parliament might be a better place to consider, they've left us in a position where I'm quite sure this hasn't ended the discussion of this type of issue, not by a long chalk. Thank you very much for listening.